So there, by virtue of the 2/3 provision of the Constitution, President Andrew Johnson was not found guilty of impeachment. The situation that also arises is, what does the Constitution say on censure? That's often asked. Well, it doesn't speak on censure at all. We only have one experience there, that was with Andrew Jackson, and he was censured by a Congress, and later when some of his colleagues that shared his political views were in power, they set aside the censure.
But that wasn't an impeachment
That
process.
was not an impeachment, so that doesn't really help us. The only one that was closer, where you had serious allegations, of course, was the case of President Nixon. But there we don't really have a good analogy, because there the president resigned. And he resigned when the Supreme Court, he had to comply with the Supreme Court decision, and together with the other evidence that was already available, it seemed that the impeachment was warranted, and it seemed that the president would have been found guilty, and therefore he resigned. So that is not an analogy to us.
There was an interesting point there, because although he wasn't impeached, he was pardoned by, I believe, the president after. Now,
well, that's because he wasn't impeached.
No, I know, but in other words, if you're not impeached, you can be pardoned by the president.
That's exactly right, but I want you to know, you know, I'm one of those who we're here to discuss the constitutional provisions. Article 2, Section 2 expressly says, the president shall be the commander-in-chief of the Army and Navy of the United States. He has the power to grant reprieves and pardons, except in cases of impeachment. By the way, this indicates that the founders gave quite a bit of thought to the question of impeachment. And it was in that same Article 2, by the way, that you find the phrase that is often used, that it says that the president shall take care that the laws be faithfully executed.
I think when they initially drafted the Constitution, they recognized there were times when they wanted Congress, the House of Representatives, and the Senate to be able to override the president. And it was so serious, and it's happened so infrequently, that, you know, that one little clause.
It was a balance of power, a checks and balances provision. But there's no doubt that a great deal of thought was given to this. I would say that for those scholars and those citizens and individuals who are really interested in reading about this, they ought to read a report of the Association of the Bar of the City of New York, right here. I know the address very well, having done so much research there over the years, 42 West 44th Street. They had a very distinguished committee. And in 1974, they were actually talking about the then problem dealing with President Nixon. And the question was, what is the law on impeachment? And that committee on federal legislation of the Association of the Bar of the City of New York submitted a report that is really splendid, which of course was a great help in the impeachment proceedings at that time. The report was prepared, may I read the words, in the interest of informing the bar and the public without taking any position on the evidentiary matters involved. And that was a way of stressing that this is a scholarly work with a degree of objectivity.
When you say evidentiary matters...
The specific case.
Okay.
The specific case. And this is, I think, the best that I have read on it, and what is the standard that is submitted here, I think, has been adopted by Professor Tribe in a splendid book on constitutional law. Tribe,
yeah,
Lawrence Tribe.
Harvard University?
Yes, Harvard University. There are several scholars that have discussed this and agree with this, but Professor Tribe has adopted the standard. Since I've read the book several times, I had occasion to review that book on one or two occasions. The concept of high crimes and misdemeanors should not be taken to mean anything that everything around which political expediency might momentarily organize a majority in the House and 2/3 in the Senate.
In other words, it shouldn't be for a political motive, it should be for...
Well, it's placed in the political branch, but the motivation should not be an exclusively political one, and that is why the entire nature of the proceedings so dramatically changed when that oath was administered to impartial justice. Actually, the word impartial, I think, is redundant when it speaks of justice. It is not justice unless it is impartial. And what I particularly like is that this report says, are the acts here, is the conduct such that we would convict not only this incumbent, but any other incumbent who has committed these acts? And they phrase it in a way that I think is commendable. We submit, said this report of these distinguished lawyers and scholars, and I think a lawyer is a scholar, since a lawyer must know the history underlying all of these concepts and words. The concept of high crimes and misdemeanors should not be taken to mean anything and everything around which political expediency might momentarily organize a majority in the House and 2/3 in the Senate. We submit that Congress may properly impeach and remove a president only for conduct amounting to a gross breach of trust or serious abuse of power, and only if it would be prepared to take the same action against any president who engaged in comparable conduct in similar circumstances.
Now, when you read that, again, the thing that our president is being impeached for is a private act that someone asked about. Now, there have been allegations that many presidents have been involved during the presidency with other people. Now, whether you want to talk about John F. Kennedy or
so that's what I should like to avoid, because I do not know what the particular case is. As having been the law member of many courts martial, where I know from experience that it's very hard to analogize cases. This isn't a situation where if you and I were senators, we would have to say, well, is this so serious that it did this, or the other? Did it pollute the judicial system to such an extent that it is a gross abuse of power? So the specific facts, that's the very awesome, difficult task of that body that isn't merely a jury, it's judge and jury. They have to pass upon, is it sufficiently serious?
You know, one of the things I noticed is that some people at this point say they don't want to run for office, whether it's for the House or for the Senate. And the reason they don't want to run is it separates them from their families.
Oh, there is a great sacrifice to public service.
Now, I know many of the members of the House and Senate have actually gone through divorces after serving because of the tension and difficulty. And I sometimes think that if you try to apply a rule of law related to this, where you ask someone about their personal lives, you know, whatever the personal issue is, you know, for example, there's always the thing, when did you stop beating your wife? Where, you know, and obviously that makes an assumption, and we don't want to make assumptions here.
No, Irvin, my answer to that would be that the question of conduct, the question of character, the question of whether you answer a question truthfully and honestly, circumstances determine so very, very much. To lie under oath in an important matter is one question. To simply misstate, no federal judge has ever sent an American taxpayer to jail because that individual misstated something on the taxes. It had to be a false statement. It had to be a fraud. In other words, the seriousness of the conduct under the circumstances is always the question, very difficult. I'm reminded in the position where, as a young officer, I was asked by the 364 or so, I think we have a special court-martial order in every case, Lieutenant, do you think I'm going to be convicted? I said, absolutely not, if the court believes you. So the question is, what are the facts in the particular case? And that's why I hate to be placed in the position of this hypothetical juror. I may have my own personal view as to the importance of the act and how it affected. Is it a gross abuse of power? Is it a serious abuse of trust? People will differ on that. Now, I believe that it would be a terrible thing if people are deterred from entering the public service. That's terrible. We should, a democracy cannot really flourish unless the very best are those who represent us. And that's a judgment made by the people.
You know, there was another instance which really isn't quite analogous, but I know when my mother was very sick and she was dying of cancer, she asked her doctor, you know, what will happen? You know, am I going to survive? And he really didn't express to her that what she had was a terminal disease. And, you know,
yes,
he did
beautiful example.
To us, her children.
Beautiful example.
You know, what would you do to the doctor? Is he, you know, not telling the truth? The answer is absolutely, no. But what harm would it have done to the individual?
Well, you know, I would have no difficulty saying to that individual, I'm not a doctor, but I would say, you know, he says, but gee, they saw me do it. So many people will testify against me. I said, you know, you just really don't know. You may very well, perhaps, your case may appeal to the court, may appeal to the jury, you may be acquitted. You can say that. That's not lying. We're not talking about that. I'm talking about something that, in effect, pollutes the judicial process. Did you see Irving Eisenstein commit that act? Is he the person who pulled the trigger? Did he have the gun in his hand? And if I commit perjury in a case where you might go to jail because I perjured myself, that harms the entire judicial system, you see. So it's hard to determine how you would feel about the case unless you know the particular case. That's why I said to you at one time, it wasn't that I don't have experiences where I've seen people commit acts and ask me, will I be convicted? Will I be found guilty? Will I win my case? Will you be believed? What is the judgment of the persons to whom that responsibility has been entrusted? Here, the responsibility by the founders, and I would say that that is the guiding star here. They have placed the initial determination, which is properly called a precondition to trial of impeachment. If that body thought that whatever they found did not rise to the level of a high crime or misdemeanor, they ought not to have, should not have, and would not have impeached. So there's no longer a question of impeachment. What is before us, what is the responsibility of the Senate? What does the Senate wish to do? And the question should be more, as that committee report indicates, should be more than merely determining how many votes of one party we have versus another. Do we have 67 votes? Well, we can only get 55. Well, that assumes that the process is entirely, extremely, and solely political. It is political, but then you have to contend with the fact that you've also taken the solemn oath to do justice impartially.
Now,
so that is the responsibility that is not yours nor mine. Very difficult.
But it raises many questions and many issues.
All before the body to whom it's been entrusted by the Constitution.
Because if the Senate voted specifically 55, Republicans for and 45 or 47 Democrats against, it would clearly appear to be something that wasn't reviewed by them based on their oath of office. Now,
and we know that will be final because these are not justiciable questions, as the Supreme Court has said. Some of the cases of the judges are absolutely fascinating. One judge was actually in jail after having been found guilty by a court of having committed a serious felony. And while in jail, he was still recovering, he was still receiving his judicial compensation. And that's because he had not yet been removed by impeachment. Then he was impeached, removed by impeachment, and, of course, having been removed from office, the compensation